Hello, my name is Tan Po Yi. Welcome to From ESG Lens. So today we are going to share about directors' duties under Companies Act to file governance report. This is provided under Section 252 of the Companies Act 2016. So let's unpack this section. What does it mean? And what does it provide? What is the significance? And what companies should do next? So this provision requires directors to file and prepare a report for each financial year. And the report must be attached to the financial statements prepared under Section 248. So this requirement is not optional, it's a statutory duty. Now the law goes further. Okay? The directors not only must prepare the report, that they must have it approved by the board and have it signed by at least 2 directors to represent all the directors of the company, or by sole director if that company happens to have only 1 director. So every copy of the report circulated, okay, to the members at a company's meeting or at the AGM, it must clearly state the name of the directors who signed that report. Why? Because transparency is crucial here. Shareholders have the right to know who is responsible for signing that report. And failure to comply with this, if the report is not signed, the report is not prepared, it carries serious consequence. Okay, a director who doesn't comply with this requirement can be fined up to RM 500,000 or imprisonment up to 1 year. So the company itself and any officer who breached this signing requirements can be fined up to RM 20,000. So these penalties highlights how seriously governance law treats reporting obligations. Okay. But here's the governance gap. Okay. While Section 252 sets out the duty, okay, and the penalties, it doesn't prescribe, okay, the content or quality of the director's report, okay, beyond attaching it to the financial statements. So what does it mean? In practice, many reports just put the boilerplate documents, okay, the standard wording, the standard phrase, get it signed and filed. But it doesn't provide any useful insights to shareholders. Shareholders not only just want to know the standard document, the standard insights, they are looking for insights, further insights of the company. And the law enforces compliance, but it doesn't ensure that directors provide meaningful analysis of risk, sustainability, or governance practices. Okay, these are the parts that shareholders want to know. Not only just the figures, not only just the numbers. So this gap means companies can technically comply. Yes, under the law, yes, you comply, you already filed, but it fails to deliver transparency that builds trust. So Section 252 is a compliance anchor. Okay? It forces directors to report and sign, but the governance requires more than just compliance. Okay? So boards should go beyond the minimum, using this director's report as a platform to communicate not just compliance, but it's a strategy, it's the risk and how it commits to ESG principles and practices. So these are the gaps that must be closed, and what separates mere compliance from genuine governance. So that is what you mean by governance. Governance is not just merely being compliant. Governance is doing more than that. You want to create value, you want to communicate what strategy you use, okay, what are the risks of your operations, and what are the commitments, okay, and sustainability commitments to make your business sustainable. So that's what shareholders want. So closing this gap is so important that directors have to take extra efforts. If they don't know what is ESG, what is sustainability, go and attend courses. Okay, build your capability to understand what are the sustainable principles, frameworks that help directors and companies to do a proper strategy for the company and the operations. All right. So that's all that we have for today. I hope that listeners will benefit from this, and we welcome any questions. You can direct to my email at ooifi@alliancehotmail.com. Until then, see you again. Thank you.